welcome to this 2020 WCA Annual Conference virtual workshop. Thank you for participating in our online event. We also want to thank our annual partners and sponsors for their commitment and ongoing support of our 2020 WCA Annual Conference. Please note our virtual workshop presenters will answer questions at the end of their presentation. Be sure to type in your question in the chat or Q&A section at the bottom of your page. If you've called in, simply hit *9 to raise your hand and be unmuted by the host. Again, thank you for your participation in today's WCA Annual Conference virtual workshop. We hope you enjoyed the presentation.
Joining me today are my colleagues Rebecca Roeker and Ben Conard, and we'll be talking about these topics as we go through the PowerPoint. Just a couple of housekeeping issues first. As you heard Michelle talk in the intro to this, there is a chat and Q&A function on your screen. You'll see the little button. Once you hit that button and start typing, that will appear to us so that we can get you the information in response to your questions. Second, this session is being recorded, and it will be posted to the Counties Association's website. That's wicounties.org. I'll remind you of that at the end of the session as well. But if you have friends or colleagues that aren't able to make it and join us today, certainly direct them to the WCA's website for information concerning this session and a lot of other good information contained on that website. So without further ado, let's start talking about this emergency that we had hoped would never happen and where we go. So as I mentioned, we're going to talk a little bit about county emergency management powers. We're going to talk about government operations and day-to-day duties associated with county government. And we're going to talk about open meetings law during an emergency. And all of those topics have changed a bit, just in terms of the way that counties conduct business. When we start talking about these different issues that fall upon counties in a state of emergency, I want you to think about the different processes that we employ. Why is process important? Well, we can't anticipate every emergency that's going to happen. That's why it's called an emergency. But what we can do is prepare ourselves for dealing with an emergency, and that's really a process question. So if we have the right process in place, and I'm talking about, again, all of you have probably heard me talk about this topic in the past, it's who's making what decision and under what circumstances. If we get that question out of the debate, we're way ahead in the ballgame. And then we can get down to the real true policy issues and the important issues that are confronting county government. So let's talk about process in the context of who makes what decisions, when, and under what circumstances. So again, I'll turn it over now to my colleague, Ben Conard, who's going to talk a little bit about county government emergency powers. And Ben gets high marks today. He wore a tie. So congrats, Ben, on looking very, very professional. And I think, Michelle, noted you trimmed up the beard today, so you're looking good. So why don't you talk about emergency powers?
Thanks, Andy. As Andy mentioned, part of the emergency power process is figuring out, having a plan in place, figuring out who makes what decision and to go from there. So for counties and other local governments, that all stems from Chapter 323 of the Wisconsin statutes. So when we're looking at Chapter 323 powers and duties for counties, there's kind of three parts to it. There's the first part, which is kind of ongoing powers and duties for counties in terms of planning and making sure that those decision makers know what their role is when the process starts, when there is an emergency situation. Part two is looking at how's an emergency actually declared, what needs to occur and be going on to kind of meet that standard. And then the last part is what are the actual emergency powers of the county during a declared emergency. So with that kind of setup, the first part then again is all counties have a duty under the statutes in Chapter 323 to plan to create an emergency management plan and program. And I guess the first set of decision makers in that process, once that to create that plan is a county committee of the board, the County Emergency Management Committee. Every county needs to designate a committee as its emergency management committee to kind of set the overall scope of the plan and direction of the plan, and to kind of to get that all set up. And then the county also needs to designate an administrative role, the head of emergency management. That's the individual who's actually going to kind of take on the bulk of implementing the plan and getting the plan moving once it's needed. So in counties with a county executive, that head of emergency management is by statute going to be the county executive or the county executive's designee. Counties without a county executive have a little bit more discretion who they choose for that role. Though I believe generally that ends up being the county administrator also, just because it kind of fits into that role pretty nicely. So the role of the emergency management, head of emergency management then is to implement the plan adopted by the board, perform other emergency management duties that the committee or the board prescribe. And also, when we're looking at Chapter 323, the statutes are kind of more general to local governments generally, so to towns, villages, cities, and counties. A difference for counties here is the head of emergency management of a county has a little extra role of doing more coordination with the emergency management heads from different municipalities within the county to make sure that there is a coordinated effort when emergencies do arise. Obviously, many emergencies, such as the current COVID-19 pandemic, don't affect one municipality only. They're often maybe over a couple different municipalities, countywide, regionally in the state, or statewide, as we're seeing now.
Let me just add here, Ben. Let me just interrupt for a second, because I think if you look at Chapter 323, I wasn't there when it was drafted. I wasn't at the table. I didn't have any input on this legislation, and I don't think Ben or Rebecca, you did either. But from my standpoint, when I'm looking at 323, I'm thinking this is the type of statute that is designed for a flood, a tornado, insurrection, a riot, things of that nature, an acute event that leads to a need or desire on the part of local government to act quickly to address that very acute event. I don't think Chapter 323 was ever drafted with a pandemic, a nationwide, a global pandemic in mind. And one of the things that I have heard in working with counties around the state is a bit of confusion about the distinction between the powers under Chapter 323 as it relates to emergency government and the powers under Chapter 252 and the other sections of the statutes that deal with health officials and control of communicable disease. And so when we're talking about the current COVID-19 environment, is it really possible for an emergency to continue for 8 months? That's what we're looking at right now, is an emergency that's continuing for 8 months. We are currently under a state of emergency at the state level. It's a declared state of emergency.
Right.
And again, 323 really wasn't, in my estimation, designed to address that particular circumstance with the global pandemic. That being said, there's nothing that says that 323 won't fit in this circumstance to deal with a global pandemic. But what I think that, at least in my estimation, ought to happen is there ought to be very, very high level communication and cooperation between health officer, county administration, county board, county emergency management as it relates to, again, who's doing what function under what circumstances and when. If you do that, if you have that discussion about who's in control, so to speak, of the various operations that are impacted as a result of this pandemic, you're going to be much further ahead. You're going to have the ability to sit down and talk about, again, the very important decisions that you need to make as a county. And so I just wanted to make this point that as we're going through this 323 analysis, understand that the statute wasn't really, I know it wasn't drafted with a global pandemic in mind, but that doesn't mean that it doesn't fit, so to speak. We just have to have an understanding of what the various statutes do.
No, you're exactly right, Andy. And I think as we've seen—
Wait a minute, this is being recorded. Did you just say you're exactly right, Andy? Because that happens. I appreciate that being recorded.
I have to say that. No, you're exactly right, though. This statute for counties is designed more for acute issues. And I think just by way of example, with COVID-19, the way we've seen counties and local governments often implement their authority under this chapter is in terms of dealing with what Rebecca will talk about in a little bit here is day-to-day operations, how to continue the function of county government during, in this case, a pandemic.
We had a question that came in, Ben, talking about the composition and the function of the Emergency Management Committee. Does it have to be standalone, or can it be part of another committee of the county board?
Yeah, I'm not sure on that. It doesn't specify.
No, I think it can be part of another committee.
Yeah.
Is whether its duties are compatible with the duties of the other committee. I'm all for trying to streamline county board committee process and county board committees. I don't like seeing counties with 57 different committees doing 57 different things. I like the fact that there are efficiencies generated by combining duties and at least for the statutorily prescribed committees, combining the names and combining those functions. But be careful, because again, you want to make sure that whatever your emergency management committee is doing, it has to be compatible with whatever the other committee that it's being combined with is doing. But I don't see anything that says you cannot combine it. But maybe, Ben, we could look at that and just ensure that we don't have some sort of statutory prohibition on it being, emergency management and, some other type of committee. Rebecca, do you know off the top of your head if it can be combined?
I believe it can, because I know that some local governments actually put it, had it encompassed in, I think one had in Public Works, which is a interesting place, and then Health and Human Services, which is a logical spot too, under this pandemic. That's
my understanding as well. All right, good. Sorry, Ben, to interrupt. Go ahead.
No problem. Just another part of this planning process that the statute requires that the county's plan incorporate this incident command system, which is developed and kind of run by the Wisconsin DOA. Kind of again with this whole planning coordination theme of the statute is that different levels of government, different agencies of the state have coordinated efforts and communication to respond most efficiently in the best way possible to ongoing emergencies. Again, kind of with this other theme of emergencies aren't necessarily just purely local; they can be countywide, regional-wide, statewide, and so on. So that also has to be part of that plan. Next, then, this is still part of this kind of pre-emergency planning and preparedness area. County boards also may appropriate funds and levy taxes for its emergency management program. So this kind of adds a component of trying to get an estimate. Obviously, it's hard to do. You're not going to be able to nail down an exact number because you don't know when an emergency is going to happen. But kind of trying to have an estimate of what the resources the county might need to combat emergencies that at least can contemplate facing. So things, again, as Andy mentioned, more the acute things like a flood, tornado, knowing that those things maybe aren't going to happen every year or even every other year, but you want to have the resources standing at the ready when those acute issues do happen.
Let me just mention real quickly, the Counties Association put an alert out last week discussing the exception under the levy limits for funds that were expended as a result of a state declared emergency, not local declared. We're going to talk about how a county declares a state of emergency, but a gubernatorial declared state of emergency. There is an exception in 660602 sub 4 that speaks to the ability to appropriate funds, have those funds excluded from the levy limit calculation so that you can deal with this emergency. So again, another consistent theme that we're dealing with here beyond coordination, beyond this high level planning, is also a level of accountability and specificity on your record keeping. It's very important that you do that from a funding perspective.
Yep, that's right. And then again, with the theme of coordination and cooperation among governments or different levels of government, Chapter 323 explicitly authorizes counties and other municipalities to enter into cooperative agreements under 660301 of the statutes to combine services, provide shared services, share resources, that sort of thing. So again, this ongoing theme of coordination among various government agencies to ensure the best response possible. So that's kind of the broad overview of the planning and preparedness process. This next part is kind of step 2 or part 2 that I mentioned earlier, the actual declaration of an emergency. How do we do that? What's required to actually declare an emergency? And that's, as Andy mentioned, I think what causes a little more confusion as well. So under Chapter 323, a county is authorized to declare a state of emergency existing within the county whenever conditions arise by reason of riot or civil commotion, a disaster, or an imminent threat of disaster that impairs transportation, food or fuel supplies, medical care, fire, health, or police protection, or other critical systems of the local unit of government. And that's the exact statutory language there. But I thought important to read through because it's, one, a lot is packed in there, and 2, you can kind of see what, like, they really try to lay out the exact scenario, well, types of scenarios in which a county may declare an emergency. And in a second here, we'll go through kind of the breakdown of what that actually means. But just from a continued procedural process, the declaration must be made by either ordinance or resolution of the county board. And to Andy's point of how long can an emergency keep going under Chapter 323, it's not, for counties anyway, and other local governments, the statute does not set any hard time limit on that, but it does require that the ordinance or resolution declaring the emergency to limit the period of emergency to when it's anticipated that the conditions will actually exist. Obviously, right now, with something like the pandemic, it's really hard to nail down any sort of estimate of how long things will continue on. So in that case, what we've seen a lot of local governments do is, especially at the outset of everything back in March, was declare an emergency existing for 60 days with subsequent sometimes renewals or non-renewals, depending on what was going on in the local government itself. And again, continuing on the procedural process here, alternatively to the board declaring the emergency, the chief executive or administrative officer of the local government, so for counties, county executive, county administrator, is also authorized to declare the emergency if the board is not able to timely meet and declare that. Now that is subject to ratification by the board, but any action that the executive or administrator took prior to their ratification or lack of ratification is not affected by whatever decision the board makes at that point. It would just be on a going forward basis whether that emergency continues.
Well, and let me just interrupt here quickly because we had a lot of questions about process as it relates to declaration of the emergency back in March when this all happened. And a lot of the questions came in, can the county board declare an emergency? Or excuse me, the county board chair, can he or she declare an emergency? Can the county administrator declare an emergency? Can the county board chair and the administrator declare an emergency? How does that process work? And I think if you look at the statute, Ben, let me know if you disagree. If you look at the statute, it really talks about the ability of the executive or administrator to declare the emergency if the board is unable to meet and make its own declaration. Because remember, the first step, the primary way that an emergency is declared is by the county board, by ordinance or resolution. It's only if the county board can't get together and meet that the executive or the administrator is empowered to declare that emergency. So we talk about it being a legislative function, and in the absence of the legislative body being able to get together and exercise that function, then it shifts over to being an executive function. That's a little different than what we've got with the state system. So don't think of this as parallel to what the state does. Remember, in the state system, so to speak, the governor declares, and then the legislature has the ability to either modify, repeal, or extend that declared state of emergency by the governor. In this circumstance, we're talking about it's a county board power, and it's only if the county board can't get together that it's an executive or an administrative power that can be exercised. And then if it is exercised, the board has the ability to come into session as a legislative body, again, ratify, alter, modify, or repeal that declared emergency. And so that's a very long-winded way of saying that let's make sure that we focus on the distinction between the legislative body and the administrative executive entity or person that is declaring the emergency. And if the legislative body can't meet, then it is solely on the executive or the administrator to declare that emergency. There's nothing wrong with the county board chair co-signing a proclamation declaring the emergency. That's just fine. And in many ways, that might be beneficial just to show that there is some sort of leadership, legislative body leadership, consent or agreement with the particular proclamation declaring the emergency, but understand that that is an executive or administrative function.
Yep. So then, like I mentioned previously, we went through the statutory language of, what is required to declare an emergency. So breaking it down, it can really be put into two components here. The first being that there must be either a riot or civil commotion, a disaster, or an imminent threat of disaster. Now, the statutes actually define what a disaster is. So we'll get into that in a minute. But so you need to have one of those three things is kind of your first condition. If you don't have one of those, obviously there's nothing, there's no emergency to be declared. The second component, though, is that the riot, civil commotion, or disaster must actually have the effect of, it currently has the effect, or it is believed, or will have the effect of impairing critical supply needs, medical care, fire, health, or police protection, or other critical systems of the unit of government. So if there might be some sort of disaster, it could be a weather event that would fit into that definition of disaster, but does not end up having any impact on these areas, so that wouldn't rise to the level of being an emergency or a declarable emergency. So what is a disaster? The statutes define disaster as a severe or prolonged natural or human caused occurrence that threatens or negatively impacts life, health, property, infrastructure, the environment, the security of the state, or portion of the state, critical systems, and so on. So it's pretty broadly defined on what a disaster actually is. Now, as Andy mentioned before, it's kind of hard to maybe shoehorn a lot of anything having to do with a pandemic into these definitions that we're talking about, because when you look at these, they're really, as Andy mentioned, talking about acute issues. A disaster or an imminent threat of a disaster that's currently happening, and then that actually has the effect of impairing these other functions of the local unit of government. So again, when we're looking at things like the pandemic, it's the powers under this section have a lot more to do with the actual effects, say, on the operations of county government, more so than the health, the ongoing spread of the disease and health impacts that are more covered under that Chapter 252 local health officer process that Andy mentioned. They're kind of different things. So any emergency powers under Chapter 323 here, again, are more geared towards acute solving problems that arise from an actual ongoing disaster.
Well, let me just jump in here quick too, because I don't think there's any question that the pandemic fits within the definition of disaster. I think you can. Correct. Right now, I think a county has the ability to have a declared state of emergency by ordinance or resolution or executive or administrator action with the board ratification process. I think that's fine. The question is, okay, what does that do? And what powers can you exercise as a result of that? And I want to focus everybody back on the statutory language about why we are declaring an emergency. And that is because we are concerned about it impairing transportation, food or fuel supplies, medical care, fire, health, or police protection. And this is important, or other critical systems of the local unit of government. It doesn't talk about controlling the spread of a virus as to why you declare an emergency. It talks about the impact on government itself, not society as a whole. So that, again, going back to our earlier discussion, talking about the need to coordinate with health officials, because the tools that are available to the health official to combat the spread of COVID-19 under Chapter 252 are different than the powers that exist within the local government under a declared state of emergency to address the emergency conditions. So again, just understand the distinction between those, and let's put these powers in the right categories and make sure that we have the right people doing the right thing at the right time according to the right circumstances. That's a good segue for you to talk about powers then.
Yeah. So then again, this is the third part of this process is what are the actual powers that a county may implement during a declared emergency. And for all of you that have been following everything going on with the response to the pandemic, especially in Wisconsin, is kind of the $1 million question is what emergency powers are authorized under Chapter 323, even from the state and level and the governor down to counties. It's not entirely clear what the scope of authority actually is. The language is very broad, and we've seen a lot of, I think, at least differing interpretations on what it means. And one of the problems that that created this different set of understandings is that there is really no authority interpreting Chapter 323 in terms of case law or any other authoritative decisions. So it's kind of, everyone's kind of feeling this out as we go, and we anticipate there will be at least more as we go on here, more guidance for the future that's not currently there. So what the statute actually says is when an emergency is declared by the county board is vested with is pretty broad authority to order by ordinance or resolution whatever is necessary and expedient for the health, safety, protection, and welfare of persons and property within the local unit of government in the emergency, and includes the power to bar, restrict, or remove all unnecessary traffic, both vehicular and pedestrian, from the highways, notwithstanding any provisions of chapters 341 to 349. So again, just looking at that language, it seems very broad. It says whatever is necessary and expedient for health, safety, and protection and welfare. And this is kind of why we've run into issues over the last few months during the pandemic is what is the scope of necessary and expedient? And that's just something that is going to have to be based on a case-by-case scenario, and should really, it goes back to when the emergency is being declared, counties should be very careful, especially in the resolution declaring that emergency, to kind of outline what the actual emergency conditions are and what the board believes the appropriate scope of the response should be. Obviously, once the emergency is declared, we're going to go through all these functions that we talked about so far in terms of the head of emergency management running through the plan and coordinating everything. But it's still really at the outset of the declaration, it's still at the board level to kind of set the scope of what the response should be to a particular emergency.
Well, and let me just say, Ben's absolutely right. There's no case out there that talks about, well, here's the scope of authority for a county under Chapter 323. Frankly, there's no case out there that talks about the county's scope of authority under 252, the communicable disease chapter of the statutes. And so what we've got is, well, we've got the legislature v. Palm decision that talks about scope of 252 authority, but then you have questions about the ability to order certain things under Chapter 323 or order certain other things under Chapter 252. We've encouraged counties to, again, separate the concepts here, deal with the emergency management function of county government under 323 and talk about the impact that COVID-19 has on the ability of the county to deliver services to its residents and citizens, and then use 252 authority to discuss the spread or suppressing the spread of COVID-19 throughout the county and society within the county. But frankly, there's been a mixing and a blurring of those lines. And you can see that mixing or blurring at the state level. The mask order, the statewide mask mandate, it's a 323 order. It's not a 252 order. Emergency order number 3, which placed limitations as it relates to occupancy within establishments. That's a 252 order, not a 323 order. So there's a lot of blurring and confusion as it relates to this. So honestly, talk to your court counsel, talk to administration, talk to your health officer, talk to your board, talk to your emergency management director, have an understanding of, again, who's making what decisions and under what circumstances, because providing clarity in that regard is going to be very, very important, not only from a county level, but also when we're talking about the public having faith in what we're doing as counties, having the public understand exactly how it is that they're to proceed in these circumstances.
Yep. And just to illustrate the lack of interpretation in case law, this is the one case that is out there for the most part on local government emergency authority. So what we do know is from this Milwaukee County case back in the 1960s is that under at least certain circumstances, curfews are an acceptable use or implementation of county government or local government emergency management powers. But this is really all we have as guidance, so it doesn't help much in the current scenario with the pandemic or even with other scenarios responding to natural disasters. So again, just illustrating the fact that there is not much authoritative guidance out there.
All right, so with that, Rebecca, will give you finally an opportunity to speak here. You've been very patient and waiting for your turn. So you get to talk about county government operations and day-to-day duties during an emergency.
Great, thank you. As you all have experienced in the last months, even though we have an emergency and a pandemic, you still have to continue your operations. You still have to provide the public services, not only that you're statutorily obligated to provide, but also that you provide just as your community service. You flipping, Andy? Thank you. So again, as we've seen with COVID, these emergency situations create questions, and as good as your county's emergency management plan is, you'll still likely have questions that arise given we don't know every emergency as best as we plan. And so these situations often cause lots of questions. So some of the questions we're going to talk about are general questions that would apply to just general emergency management, whether it be a natural disaster and so forth, or the other questions that we've seen specifically in light of our pandemic. So again, we're going to talk about day-to-day operations, what activities may you suspend as county government, restricting building access. That became a very important issue in the last few months, and then protecting employees. Of course, we all care about our county employees, sure they're safe, as well as people who come in for county services. First thing we always look to is the emergency plan. As Andy and Ben stated, there needs to be coordination with the state emergency plan. So your emergency plan is not going to address every situation, but it will, or it should address the high level points. And so you want to look immediately to your emergency plan. The under 323.14.3b, it specifically references what your emergency plan requires. So not only is it a good idea to coordinate your emergency plan for state and local coordination, but the statutes also require it. So that's in both the of a governor's order and also during a time of a natural disaster or a local disaster. As we've seen across our state several times, there may be natural disasters from floods that flood out roads. So you may see state involvement, federal involvement, just to address those local disasters that other counties experienced, or if it's a regional emergency, there might be just local coordination. Next. What if your emergency plan is silent? Of course, your emergency plan is not going to address emergency, because emergencies can't be foretold with your crystal ball. So what are some other resources and requirements that you should be looking to? First is your COOP plan. That's a continuity of operations plan. I found that in our work with county government, sometimes a COOP plan is either neglected or it's not revisited in with as much frequency as maybe it should. So we encourage you all to take a look at your continuity of operations plan and make sure that you and your employees and your directors and so forth all have a good understanding of what that plan requires. Also, we may have federal declarations and restrictions. So if there is a disaster declared, which moves to our next one, there may be specific restrictions that you have to follow in order to have or in order to receive that aid, whether it be from the federal level or the state level. As we've seen with COVID, there's government or governor emergency orders under the law. If there is a state law, it may preempt, usually preempts what the county order will be. So, for example, in COVID, we saw some local orders that were not consistent with the state order. Technically, those local orders were not enforceable because of that, because of the inconsistency, and again, the theory of preemption. Now, obviously, in COVID, we have other issues throughout the state with respect to enforcement and so forth, which we won't get into here. Next is what's your statutory authority to restrict your operations? So under the statutes, there are certain services that you have to provide as a county. What can you restrict? Under 323.14 4A, the county board may rely on its power by order, ordinance, or resolution, which we just spoke on a little while ago, whatever is necessary and expedient for health, safety, protection, and welfare of persons and property within the county. Now, again, very broad, and depending on what the situation of the emergency is, it's going to be very factually based what steps the board can take to restrict those operations. So what are some examples that we may see or we did see of how 323.14 can impact county operations? Throughout the COVID experience, many counties set forth orders or directives for what activities can occur on county property. So for example, some counties imposed a masking order or a facial covering order if you were to enter county property. Some people or some citizens had, some issue with that because at the point in time where the state wasn't under a masking order, well, how can the county be? And again, it can be a county order if it's not inconsistent with state law by the theory of preemption, and also because the county is regulating what activities occur on county property. And so while it may be, you may have a situation where it's legally appropriate to require masking on county property. Obviously, the public relations factor can be a different issue for lots of folks. Next is suspending non-essential services. When the pandemic first broke in March, I think Andy, Ben, and I received lots of questions on what was an essential service and what wasn't. And again, because of our lack of case law, that's a very factually based question. What is essential? What is not essential? Limiting county building access to a central location. Under the law, you cannot lock the doors of the courthouse, but you can restrict access to central points. This, I think, is one of those features and experiences that counties have learned through the pandemic is actually a very good practice. So, maybe but for this pandemic, counties wouldn't have realized a central flow of access to their courthouses or other county buildings. Maybe they wouldn't have tried it, but now they haven't, and they see it works better from a general operational standpoint. What can a county not do? Number one, you cannot restrict access to the court. That is, when we're talking about the courts, we're talking about a whole other body of law that applies as an overlay to the Wisconsin court system. And so that is also why if there is preemption. So in the area of the circuit courts, the Wisconsin Supreme Court and the director of state courts orders have to be followed. You can also not close constitutional offices. Those are the county clerk, the treasurer, register of deeds, sheriff, and so forth. You certainly can limit staff or have a hybrid model of staffing, which we saw lots of counties do, or take other protective measures such as drop boxes for register of deeds document recording. Those measures are, again, they have to be reasonable and depend on the facts. So you can take those steps to restrict operations, but you cannot close those constitutional offices. County employees are always an important feature of how we're trying to deal with this current pandemic. How do we keep employees safe, but still, again, providing these essential services? So what can you do, or what did we see happen throughout this pandemic? The COOP plan, again, that continuity of operations plan is very important. And also, if you practice through your COOP plan, it's kind of like the fire drills that you experienced in grade school. Still an emergency if you have to activate the COOP plan, but if you go through the practice, hopefully people will be more familiar with it. Employee safety. Is it even safe to work in the office? Telecommuting or telework obviously became a huge, really an explosion in the difference of the culture of a workplace during this pandemic. So again, each county has to look at what facts and circumstances are appropriate for that county. But we did see lots of telecommuting during the pandemic. If there is within the office, you may have to take other steps than just general telecommuting. But again, those are very factually based. Management challenges of telecommuting or telework can be challenging. And that's where your HR department and your department heads really have to sometimes put your heads together and think of data points or ways to monitor to ensure that work is getting done. I always joke that working from home is a great opportunity because you can always throw a load of laundry in, which you can't do in the office, but you still have to obviously make sure your work is getting done. So while there is a little bit more flexibility, obviously employees still have to get their work done, and sometimes coming up with measurables for that can be a challenge. We saw lots of employee questions when the pandemic arose. Some specifics that we saw during COVID-19, FFCRA, EPLSA, and then very frequently, how does FMLA impact, how is it impacted by these other potential benefits that employees may receive? Other day-to-day considerations, public services, again, key public services are going to depend on what the emergency is. So if it's a natural disaster, the public service, you may need more law enforcement. You may need your highway department more. You may need your public works force more. So again, it really depends on what is the nature of the disaster. Shifting to a few counties saw that in order to deliver PPE or in order to make sure that dissemination of health services was accommodated for, they actually had to shift some staff from one department either to public health or other services that required a greater staffing need because of the pandemic. So again, that's a management and departmental issue. But again, very unique. We've never seen that before. At least I've never seen that before. Communication with the public. It's so very important, as I'm sure you all know, not only just from a communication standpoint in terms of what is happening and the pandemic's impact, on your county, but then also to share what public services or what county services are impacted by the pandemic. So for example, lots of counties switched to appointments only. So for example, if a citizen wanted to come in and apply for a rezoning, usually they can just walk in and talk to the person at the front desk. Well, counties now made appointments required. So again, that's a change in your day-to-day operations, but it was necessary in light of the pandemic.
Great, thanks, Rebecca. I'm going to spend a couple of minutes just talking about open meetings law compliance. I know that in the past we talked about this topic, and I think others have talked about this topic as well. We saw the Attorney General come out with a couple of guidance documents, and so it's always important that we have a refresher, because I'm starting to get questions from counties about, hey, we kind of like this virtual or hybrid meeting model where we have people that are appearing remotely. Can we continue it, and how do we continue it in compliance with the open meetings law? And so always good to have a discussion, a very brief discussion, just overview the open meetings law, its requirements, and all of the various legal considerations that come into play in a virtual environment. I want to start with this because I found this incredibly insightful. It's funny because it's a cartoon, but it's insightful in that you'll see that the press here is questioning the motives of a newly elected official. The reason that I think that this particular diagram or cartoon is insightful is because it's the press that is going to be watching this. It's always the press that is watching this. And so even though we might have a public that fully buys into a hybrid model, a virtual model, whatever the case may be, it's the press that is going to raise some sort of complaint or stink about it if they believe that there has been a problem under the open meetings law. So just keep that in mind. So here's the rule. This is from the Attorney General's Compliance Guide. All right, two very fundamental basic requirements of the open meetings law. One, we have to give the public advance notice of each of our meetings of a governmental body. And two, we have to conduct all of our business in open session unless there is a particular statutory exception in 19.85 that applies. So what about virtual meetings? There is no exception within the open meetings law statute for virtual meetings. That doesn't mean we can't do it. It just means that we have to conduct those meetings in a way that complies with the open meetings law. What does this mean? If we're going to meet remotely, that means we have to give the public access to the meeting, either remotely or at a location that the public can access. So here's the challenge. I know that in the past, there would be county board committees that would meet by telephone conference, and the way that the public could monitor that meeting is by traveling to the courthouse, going into a room, and in that room was a speakerphone where the public could listen to the conversation that was occurring in the context of that committee meeting. That is compliant with the open meetings law. That's fine. Remember, the public has a right to participate, or excuse me, a right to monitor, not participate. So you don't have to make it so that the public can talk to the committee. You just have to make it so that the public can listen to the committee. But now when we're dealing with the COVID-19 pandemic and we've got all sorts of best practices or orders out there that talk about a limitation on gatherings and a limitation related to social distancing and whatnot, how do you allow the public to monitor that meeting? Do you have to provide them with a dialing code? Do you have to provide them with Zoom access? This webinar is being recorded by Zoom. Do you have to give the public that Zoom information so that they can dial into the meeting? Great questions. And that raises a whole host of other issues. The other issues are, remember again, the public has no right to participate in a meeting. The public has a right to monitor the meeting. So if you give the public the same access code that you give the county board members or committee members, the public is going to be able to participate. That might not be the greatest. I think everybody's read the headlines all around the country about people doing Zoom bombing, where they all of a sudden appear at a meeting and do things that are rather inappropriate. And frankly, things just occur in the context of these video conferences and video meetings. I'll never forget in March, my son, who was a senior in high school, was home, learning from home. I was in his room at the time that I was on a statewide Zoom meeting, and in he walks in his boxers, his underwear, to pick up his laundry right behind me on the screen. So everybody had a nice shot of my son walking in my background in his boxer shorts. That kind of stuff happens on Zoom meetings. So we have to be careful about who we are granting access to in the context of these meetings. So here's some practical pointers. If our goal is to make sure that we have maximum transparency, have public monitoring of these meetings, how do we do this in a virtual environment? First, the notice of the meeting. Remember, this is one of the two primary reasons that the open meetings law exists is one, to give the public notice that we are going to transact or conduct the public's business, all right? First, the notice of this meeting, provide options for the public to access the remote means of communication. And that, according to the Attorney General, that access should be of similar quality to that of the body. What does that mean? That means if the governmental body is going to meet by video conference, it's not enough for us to simply allow the public to monitor by telephone. Monitoring by telephone does not allow the public to gauge body language, facial expressions, and other elements of communication that sometimes are just as important as the spoken word. So if we're going to meet by video conference, telephone line only option is probably not enough. The other consideration that we've got here, we have to provide provision ability for the public to somehow monitor the meeting if they don't have, for example, broadband access. Not everybody in the world has access to the internet. So if we're going to do a video conference platform over the internet, how is it that we are going to provide the public with the means to monitor that particular meeting of the governmental body if they don't have access to the internet? Now, there are different ways that you can do this. One of the things that I really like, and I've seen this on a ton of agendas for years in county government, is at the bottom, it's an accessibility statement that says, if you have problems accessing this meeting, please contact the clerk's office to evaluate our ability to provide accommodation to you to attend this particular meeting. We could do the same thing here. Have that same accessibility provision at the bottom of the agenda, talking about anybody who doesn't have the ability to access the meeting vis-a-vis the internet, call the clerk's office and we will make provision for that particular member of the public to access the meeting. Third bullet point, and this is an area where it's been a particular concern. This was primarily back in the early stages of this, but I think it will continue to be a concern now, is that what if the body meets in person? It's a 5-member body. That body is able to socially distance in the context of that meeting. And so they're sitting 10 feet from each other in this meeting. And then they're going to live stream this meeting on the internet. And so they're saying to the public, you have the ability to monitor over the internet, but we're going to meet in person. You can't come to our county facility to monitor this meeting. According to the Attorney General, this is problematic, although the Attorney General has not come out with a hard and fast statement on this as far as I'm aware. But it's problematic because the public should be allowed to attend in person if the committee or the governmental body is going to be there in person. Again, that's a problem because what if we have 50 members of the public show up to monitor this meeting and the particular facility where this meeting is taking place can't accommodate 50 people in a socially distanced environment? And so we have this convergence of the public health ideals and the open meetings law ideals, and what wins. And so I think we have to try to do the best that we can under these circumstances. And that's an important point because the Attorney General has said that in terms of compliance measures under the open meetings law, we're going to take a best efforts type approach while we're in the midst of this pandemic. So as long as we have good faith being exercised on the part of our public officials, we're not going to go out and start citing folks based upon technicalities under the law. Doesn't mean you can ignore the law. Doesn't mean you don't have to comply with the open meetings law, but let's use good faith and best efforts to guide our decision-making process. If we know that in a particular issue is going to generate a ton of public interest, then let's make sure that we have the facilities prepared to allow the public to monitor what it is that we're talking about. If we know that it's not safe to have 50 people crammed into a small room, then let's maybe have the governmental body meet by remote means and then spread those remote means out to the public so they have the ability to monitor. In other words, let's use some common sense here as we're going through this entire process. All right, so next, some other practical pointers, and this relates to running the meeting, because in a virtual environment, the meeting is a lot different than it is in a live environment. So I always like it when the county or the chair of a committee has some rules that they have established as it relates to running the meeting. And then we go over these rules at the beginning of every meeting. Number one, people have to talk slowly, and people have to understand that there is a mute and an unmute button on your screen. All right. And so if you're not talking and it's not your time to address the body, hit mute, because nobody wants to hear your home phone ringing in the background. Nobody wants to hear the dog barking. Nobody wants to hear a kid yelling. Everybody wants to hear what business is being transacted by the body. So number one, advise people to speak slowly and advise them to use the mute and unmute button. Second, if you're not in a private space, use a headset. They're available, they're out there. Maybe a county can provide those to certain members who don't have them, but they do a lot in terms of muting the background noise. If you're going to leave the meeting, don't just turn your camera off and take off, because then we have no ability to determine if we have quorum, if we have enough members present to transact a particular piece of business, and so on. So make sure that you announce the fact that you are leaving the meeting and ask the chair for permission. Avoid using the chat function during the meeting, just like when we had in-person meetings prior to the COVID-19 pandemic and we said don't text one another during the meeting. Avoid the chat function so that the members are not talking privately in the context while the meeting is going on. And so again, let's keep the government's business within the public's eye. And then give the chair the ability to use technology features to make sure that everybody has a fair chance to speak. And so the chair can try to shepherd the entire process through the meeting in the most expedient way possible. The chair ought to have a really, really solid and good understanding of how the technology works. And frankly, I think that there ought to be one person who is in that meeting, not a member of the governmental body, but is just in charge of the technology. That way, if there's a glitch, if there's a problem, we have somebody other than the chair or a committee member that can take care of that problem. So I think that would be a good idea as well. Remember that we can meet in closed session in a virtual environment, but it becomes very, very difficult. There are specific reasons that you can meet in closed session. Those reasons haven't changed as a result of the pandemic, but there are some particular concerns in a virtual environment. Again, we have to have an agenda that notifies the public that we're going into closed session and for what duration. Are we going to come back out into open session potentially and take action? How do we put the public out of a closed session meeting and then invite the public back into an open session in a virtual environment? That takes some forethought. It takes some planning in terms of how you create the agenda, and again, how you try to create the technology platform to allow that type of thing to occur. Some questions: how are we going to convene and conduct business in closed session? How do we ensure that our communication is close to the public? Again, we may be able to take the public out of a closed session virtual environment, but how do we ensure that no other member of a person's family or a friend isn't in the background of that particular committee member's household? So we have to have some assurance that it's truly a closed session. Other practical pointers, as I mentioned before, have somebody in charge of the technology and in charge of the meeting process. Ensure the cameras are on so that we can identify who's speaking. If we're using a telephone conference, before the member starts speaking, ask the member to identify themselves. This isn't so much for the committee members as it is the public, because we as county board members or county committee members may know very well whose voice is speaking, what the public isn't going to be able to know. So make sure that those participants identify themselves. Avoid recording a closed session part of the meeting. Zoom has a record function. Don't have the record on during a closed session because, again, that may become subject to a public records request. So you got to be very cognizant of that. We do have a couple of questions here that I wanted to get to because I know we're near 10 o'clock, which is the appointed time for us to adjourn, but I want to address these questions. And again, feel free to stay on. We're going to stay on for another 10 minutes or so to get through some of these questions. And if you have additional questions, please type them into the Q&A or chat feature. All right, first question. Are there any updates on any of the challenges for public health officers as it relates to their powers? We have the Dane County case that is proceeding. It's in briefing. It's set for oral argument at the beginning of December. That case deals with the extent of a local health officer's authority under 252.03 to close public and private schools. I think that case is going to address the scope of local health officer authority under 252.03, so we'll have to see how that case unfolds. We have the mask mandate, which was upheld. We also have the state emergency order number 3, which placed a limit on public gatherings. That emergency order number 3 has been enjoined. The Court of Appeals issued a decision late last week indicating that emergency order number 3 is unenforceable. So that's kind of where we stand on public health officers and their powers. Next question, is it improper to turn the camera off during the meeting. I've been in meetings where people have kept their camera off all or most of the time. It's not improper. There's nothing against the law with turning a camera off. I think we encourage to have that camera on to the extent possible so that we can identify who is speaking on what different topics. But again, there's no prohibition on having the camera off during a meeting. Next question, are community action program board meetings exempt from open meetings law? That's going to depend upon the circumstances and what that community action program board is, whether it is a governmental body. If you look at the case that came down, gosh, 3 years ago, I believe now, it's the case Krieger versus Appleton Area School District. That's a detailed explanation of the types of governmental bodies that are subject to the open meetings law. So I would encourage you to take a look at that case. Again, it's Krieger versus Appleton Area School District. Those are all of the questions I've got in Q&A. And so let me just give it a moment here. First, I'll ask Ben and Rebecca if they have anything that they want to add, because I rattled through a ton on open meetings law. Maybe you have some practical pointers that you've seen out there as well. I'll ask you if you have any input on that.
I don't. I think that, for lots of counties, if not all counties, it was, it felt like a clunky experience, to have Zoom meetings, and there was a large learning curve. But at least experience it seemed like county citizens were understanding. Technology for board members be a challenge, but it seems like people are working. And particularly as the number of positive cases goes up, I think counties are returning to a more virtual than they were before. So I think it's really important to stay on top of the technology, and particularly, as you said, Andy, have the committee chairs and the board chair, really have a good understanding of what the technology is.
So we got another question in here. Is it appropriate or okay to ask who's joining a meeting remotely if they're a member of the public? You can ask, they don't have to answer. Let me just note that there are some ordinances out there that require that a particular meeting have a public comment section. A public comment is not required by state law, so you don't have to have it there, but many counties like to have a public comment section on their agenda. And many counties have continued with public comment even in the virtual environment. As part of public comment, you can certainly ask that the person speaking identify themselves, identify their residence or location so that you know where they're coming from in the county, and things of that nature. You can limit public comment to matters that are germane to the agenda, for example, as well. So you can put conditions on public comment, but in terms of who is actually accessing the meeting and monitoring what is going on, there's nothing in the law that would allow you to compel somebody to say who they are or where they're from or who they represent or anything of that nature. So you can always ask. There's nothing wrong with asking, but they don't have to tell you. Let's see, we have a couple more questions that showed up in chat here. The sound is going in and out as I speak. I apologize if that's the case. What do we do if our county hasn't gone virtual for any meetings yet? And that's a good question, because I think counties are grappling with what type of environment they want to hold their meetings in as we go forward, pre, post, during COVID-19. And so I think it's a question of what works for your county. It may be that a virtual environment just simply doesn't work, in which case you coordinate with your health officer and county administration to set up the meeting in an environment that is as safe as possible under the circumstances. If you're going to go to a virtual environment, you have to investigate technology options, figure out which platform is going to work best for you, and then figure out again how you grant the public access to those meetings so the public can monitor what it is the committee or the county board is doing. And so there are a lot of considerations out there, and I think that a lot of our colleagues, county colleagues around the state, counties have learned an awful lot over the course of the last 8 months as it relates to these virtual meetings. So lean on your colleagues around the state to find out what works and doesn't work, and have an open discussion about those different features and different aspects of technology. All right, so I think that is all of the questions that I see in Q&A. I don't have anything more in chat. Maybe I'll ask Anne Marie or Michelle if there's anything else they want to add. Let me just note that, again, this entire webinar was recorded. It will be available on the Counties Association website, www.wicounties.org. And feel free to share it with others. If you have any follow-up questions on anything that we've discussed here, absolutely feel free to reach out to me, Rebecca, Ben, WCA, and we'll try to get information to you as we can.